honorable resource person, chief guest, dear teachers, my colleagues, and one and all present over here. A very good afternoon to one and all. I, Yaqub Murtaza, co-author, is presenting this paper on behalf of Honorable Author Dr. Nasima PK, Assistant Professor, Department of Law, Aligarh Muslim University, Center Malappuram, Kerala. The title of the paper is Impact of Digital Technology on Intellectual Property Rights. So let's begin with the introduction. Digital technology is impacting traditional enforcement mechanism. On every next day, it is making the copy, transfer, transformation, and manipulation of information and intellectual works cheaper, faster, accessible, and more private. There is no doubt that in the era of digital technology, the infringement of copyrights occurs at a large scale, and thus it became more prevalent and harder to detect and prove the infringement. For example, personal computers can store, process, and communicate the contents of large commercial databases without the consent of the owners of such works. As a result, owners of the rights face greater difficulties in detecting, proving, and stopping the infringements. Thus, widespread and unimpeded infringements may also undermine the legitimacy of the intellectual property rights. The impact of digital technologies is different for different intellectual property rights, and the author will try to discuss many of them and will try to find out the best solution to protect the intellectual property in the digital world. Now moving forward, the problem of copying and the effect of storage devices. The advancement of digital technology has put the world on our fingerprint. It has made access to the world easy and the reach of copyright works extended. If we want to search any information, any literary or artistic works, we just one step away to get access. We have to Google it. This is the positive impact of digital technology, but it has also negative impacts. Such storage technologies became cheaper and capable of storing more information. Thus, it became harder to enforce intellectual property rights. Information in the computerized digital form is much harder to control than information in the traditional formats. In the mid-20th century, photocopying, Xerox were developed. More people began to copy text, graphic images, making it harder for the copyright holders to monitor such activities. These changes have made copying a greater problem for copyright protection than it has ever been before. Moving forward, the impact of audio-video tapping on IPR. The widespread availability of audio-video tapping technologies has brought more about unauthorized reproduction of recorded music, video, and motion pictures, wherein personal use are allowed for some specific purposes under IPR, and it is not infringement of the copyright under Section 52 of the Copyright Act. But the section requires reconsideration, and the language of the section is not appropriate or inclusive to include all the infringements. Moving forward, impact of the computer on enforcement of the copyright. The growing use of computer to do the works and to store information has made it even more difficult for copyright owners to enforce their rights. In the case of controlling reproduction, the computer poses three major problems. Number one, copying digital information can be done in a fraction of a time. Second, an infinite number of perfect copies of material can be made. Third, a computer can make many copies of the parts of a work. The content of a work can be completely separated from the medium that carries it into another form and may be held in permanent form on magnetic disk. Because of these loopholes, computer pose novel questions for the enforcement. For example, at one point in proprietor's right to control copying violated in a user's computer system. Similarly, how much of the material that places in a computer can or should be recognized as part of the copyrighted work. Section 51 of the Copyright Act addresses the situation when the copyright infringed, but the language has yet to be widely tested and some additional points should explicitly be included. Moving forward, I would like to suggest some points. Apart from these points, which I have mentioned right now, print live performance, impact of radio, television, impact of communication satellites, pessimize data communication, copyright can also occur in these circumstances. These are some serious questions and challenges created by digital technology. And IP right laws seems to be lacking in addressing such problems, to be providing effective measures to deal with such intellectual property rights violation and challenges. Therefore, in order to complete protection of copyright, it is also highly important to create a separate body to have check and balance on intellectual property and rights. It is also necessary that there should be some liabilities of the internet service providers, as Section 79 of the Information Technology Act 2000 addresses this issue, but the language of Section 79 of the Act needs reconsideration. Thus, only copyrights may be protected properly, and for the benefits of society, we could be able to control infringement of copyrights through digital technology in the world of digital technology. Thank you. Open for questions.
For the infringement of copyright or any intellectual property right, how can we make the service provider liable? What is the basis of the liability of that service provider? They are only giving a platform, isn't it?
No, actually, sir, Section 79 of the Information Technology Act talks about the liability. When the internet service provider continue to provide the service with the knowledge that there is something happening that is the infringement of copyright, even though they are providing the service, that will come under the liability of internet service providers, but the section is not much wider. So therefore, it requires the reconsideration to include some more grounds of the infringement of the copyrights under the Copyright Act.
What are the grounds under that section?
Under Section 51 of the Intellectual Property Rights, 1957, there are some grounds. For example, without the consent of the owner, if you are using any literary and artistic works, that will come under the infringement of the copyright. Another point is that, for example, they under Section 52, fair use and personal use. For example, as a student, if you want to get research on any topic, it is allowed. For library, it is allowed. But if you are misusing that permission, so it will come under the infringement of the copyright.
So my question was that suppose you are performing a program on the stage,
Right.
and that your performance may be violating if you are singing a song. For that, I am the provider of that stage. How I will be liable for the infringement? That's my question.
Sir, performance rights have not been included under the copyright. So that is the shortcoming.
That's only an example.
Yeah, that is the shortcoming.
I have given you only a platform.
For
And
that,
for that purpose, how I can be liable for that?
if you are doing live cast without the permission of the speaker, so it will also amount to the infringement of the copyright of the author. Thank you very much.